When you step into a modern workplace, there is this implicit expectation of order.
Oh, absolutely.
Yeah.
Like everything is neatly boxed up
Right. You sign your contract, you read your job description, you meet your HR department. It feels like a machine that should just run smoothly as long as everyone does their job.
on paper. Yeah, it looks perfect.
Exactly. But then you throw human beings into the mix with all our messy lives, our families, our conflicts, our breaking points, and suddenly that well-oiled machine starts making some very, very strange noises.
Yeah, and the reality of workplace rights is, well, it's rarely as neat and tidy as the employee handbook makes it seem. When that machine breaks down, the results can be catastrophic for the people caught inside the gears.
Both financially and psychologically,
Oh,
though.
without a doubt, it ruins lives.
Which is why we are welcoming you to today's deep dive. We are going to be navigating the incredibly complex, often shocking, and frankly messy realities of Australian workplace rights.
It's a wild landscape out there.
It really is. And our sources for today are this fascinating trove of case studies and legal articles from AWDR, that's the Australian Workplace Discrimination Representatives.
And it is worth noting who they are, just to understand the perspective of the sources we're analyzing today. AWDR is a team of non-lawyer workplace relations specialists.
Right, non-lawyers.
Yeah, exactly. They've spent over 30 years representing everyday workers who are facing unfair dismissal and discrimination. And they operate on a no-win, no-pay basis to make justice affordable.
Which is huge for people who just lost their income.
Absolutely. And they handle thousands of these disputes across the country.
So the mission for our deep dive today is to take a magnifying glass to the fine, sometimes incredibly blurry line between genuine workplace discrimination and a completely justified dismissal.
It's a line that gets tested constantly.
For sure. And we are going to do that by looking at two shockingly different real-world pregnancy discrimination claims from 2025 and 2026 that went all the way to the federal courts. Okay, let's unpack this.
Let's do it.
Because navigating a workplace dispute is not about just walking into a tribunal and yelling unfair. It's about choosing the exact right legal instrument.
That is the most critical part of the whole process.
Right. It's the difference between needing a sledgehammer and needing a surgical scalpel. You don't always need the wildly expensive chief engineer like a corporate lawyer. Sometimes you just need a highly experienced mechanic who knows exactly which wrench to turn.
I like that analogy.
Yeah.
Because in the Fair Work system, choosing the wrong instrument or filing the wrong type of claim, it can completely derail your case before it even begins.
Oh, really? Just from filing the wrong form?
Oh, yeah.
Yeah.
The legal mechanism you choose dictates your entire burden of proof. It changes the whole game.
Well, let's look at a case where the workplace didn't just break down, it became actively hostile. We're jumping into our first major case from the sources. It's Duarte v. United Arab Emirates Ministry of Foreign Affairs, a federal ruling from February 2026.
The details of this one are they're staggering.
Staggering is the right word. So the setup here is we have Tatiana Duarte. She was working as a full-time waitress and cleaner at the UAE's Melbourne consulate. Everything seems entirely standard until April 2020.
Right. When she informs the consul general, Dr. Nariman Al-Molla, that she's pregnant with her first child.
Exactly. And under normal circumstances, that should just be a congratulations and a chat with HR, right?
Yeah, because under the national employment standards in Australia, notifying your employer of a pregnancy triggers a very specific set of legal protections and entitlements.
Which makes sense.
Right. It's supposed to be a standard procedural reality. It's a biological fact of the workforce, not a catalyst for punishment.
But punishment is exactly what she got. I mean, the treatment Duarte faced, as outlined in the court documents, is honestly hard to read. She requests her standard paid parental leave. Denied.
Just flatly denied.
Yeah. Then she asks for unpaid parental leave later on. Also denied. Then, in May 2021, while she is literally still caring for her newborn, the consul general demands she return to work immediately.
And completely changes her role, too.
Yes. To a butler. But then we get to the detail that just stops you in your tracks. When she returns, because they gave her zero notice to find childcare, she obviously needs to express breast milk during the day.
As any new mother would.
Exactly. But Dr. Al-Molla forces her to do this in a storeroom and refuses to provide any refrigeration.
It's so degrading.
It gets worse. Duarte has to bring a suitcase filled with ice just to store her baby's milk safely. A suitcase of ice.
The psychological impact of a scenario like that, I mean, it cannot be overstated. A clinical psychologist actually provided evidence during the federal proceeding.
I read that, yeah.
They showed that Duarte was suffering from high levels of stress, showing clear, measurable symptoms of prolonged chronic stressors. She wasn't just inconvenienced, she was systematically humiliated.
Wait, I need to stop you there and push back on the whole premise of this jurisdiction.
Okay, go ahead.
This is a foreign embassy. Isn't that technically sovereign soil? How does an Australian federal court even have the jurisdiction to fine the United Arab Emirates Ministry of Foreign Affairs? Did they just think the rules didn't apply to them?
That is the exact tension that makes this case a landmark. Diplomatic entities do operate with a certain level of assumed immunity for official state acts.
Right, diplomatic immunity.
Exactly. But when they hire local staff under local contracts, employment law still applies.
Yeah.
The federal court essentially ruled that running a consulate doesn't grant you a blank check to ignore the national employment standards.
So they can't just do whatever they want.
No, they can't.
Yeah.
And what happened here wasn't just a simple case of unfair dismissal. The legal mechanics are much heavier. This was a severe general protections violation under the Fair Work Act.
Okay, break that down for us, because how does a general protections claim actually function differently from regular unfair dismissal? To someone listening, getting fired unfairly sounds like the same thing.
Yeah, it's a common point of confusion. Think of unfair dismissal as the sledgehammer. It's essentially arguing that a firing was harsh, unjust, or unreasonable.
Like they didn't give you a warning.
Right, or they fired you for a minor mistake without following a performance plan. But a general protections claim is the scalpel. It alleges that an employer took adverse action against you.
Like demoting or firing you.
Exactly. But specifically because you exercise a protected workplace right. In this case, being pregnant, requesting leave, and needing breastfeeding accommodations, those are protected rights.
So it's about the reason behind the treatment, not just the treatment itself.
Spot on. Furthermore, general protections claims carry a reverse burden of proof.
Reverse burden of proof. What does that mean?
Well, in a standard unfair dismissal, the employee has to prove the firing was unreasonable. But under general protections, the moment an employee proves they have a protected trait like being pregnant, the burden of proof completely flips. Yeah, the employer is legally presumed guilty of discrimination unless they can provide a paper trail, proving they took action for a completely different, valid reason.
And the UAE obviously couldn't do that.
Not at all. The court found that Dr. Al-Mullah's actions were a calculated campaign of discrimination specifically meant to induce Duarte to resign.
And when she didn't resign, they just made her role redundant in October 2021 and handed her a tiny payout.
But she fought back.
She did. She takes this to the Federal Circuit and Family Court, and the legal fallout is wild. The ministry hires top-tier lawyers, Clyde & Co., to defend them. But the lawyers literally can't do their jobs.
The procedural details here are staggering. A default judgment in the Federal Circuit isn't just an automatic win, you know? The judge still has to look at the evidence.
But the lawyers had nothing to work with.
Right. Clyde & Co. couldn't mount a defense because the UAE embassy in Canberra simply refused to give them instructions. The lawyers actually had to file formal submissions with the court, basically saying, we have no evidence and no instructions from our client to contest this.
Which feels like the ultimate legal form of just ignoring the engine light on your dashboard. You can't just close your eyes and hope the judge goes away.
It never works out well.
And because of that stalling, the court issues a default judgment in February 2026. The financial penalties they handed down are massive. The total payout ordered was $203,256.99.
A huge sum.
Let me break that down for you because the numbers explain the mechanism of the law here. There was $48,190.46 in lost salary and superannuation.
Which is Australia's mandatory retirement fund system, where employers pay a percentage of your salary into a locked account.
Right. Then there was $25,000 for non-economic loss, and the court specifically noted that was for the obvious hurt and humiliation she suffered in that storeroom.
The suitcase of ice.
Exactly. But the biggest chunk, a massive $100,000 in pecuniary penalties.
Now, a pecuniary penalty is essentially a punitive fine. It's not just about compensating the victim. It is about the court punishing the employer to deter future bad behavior.
Especially because the litigation was dragged out for years by the ministry stalling. They were basically punishing them for ignoring the court.
What's fascinating here is how the court viewed sovereign accountability. The Melbourne consulate actually closed its doors in August 2022.
Oh, right. They shut down completely.
Yeah. And Dr. Al-Mullah The person who perpetrated the discrimination had packed up and moved on to a new post. But the court ruled that the ministry itself was strictly responsible for the conduct of its officers.
So they couldn't just run away from it.
No, it sends a very clear legal message. Employers cannot simply close up shop or move the bad manager to a different state to escape accountability. The liability sticks to the entity.
Man, the Duarte case is a perfect example of the law acting as a necessary shield for the vulnerable. It proves the system works when the discrimination is that undeniable.
But it's not always that clear-cut.
Right, because that raises a darker question. What happens when an employee tries to weaponize that exact same shield to hide their own dangerous behavior?
Yeah, we have to look at how these exact same legal protections can be tested in reverse.
Which brings us to our second case, decided in late 2025, Talagon v. Alight Kiidi Ltd. We have Axel Talagon. She's a contracts officer at an industrial equipment supplier in Western Sydney.
And like Duarte, Talagon is pregnant.
Exactly. She is expecting her second child, and she is the primary carer for her 6-year-old daughter because her husband works a fly-in, fly-out schedule.
Meaning he lives and works at remote mining sites for weeks at a time before coming home. That's a really tough setup for any family.
It is. But then, in May 2023, she is fired. She files a general protections claim saying she was targeted and dismissed because of her pregnancy and her care responsibilities.
And if you just read the initial filing, it sounds horrifyingly similar to the first case, right?
Totally.
A pregnant mother juggling childcare without her partner, being pushed out of her job by a heartless corporation.
But then you look at the explosive catalyst for her actual firing, which happened on April 5, 2023. I mean, imagine you're managing a team and someone commits a massive safety violation, but they also happen to be pregnant. How do you legally protect your company while respecting their rights?
It's a minefield.
It really is. So Talagon has a childcare issue, so she brings her 6-year-old daughter into the office without getting permission.
Which is already problematic.
But she doesn't just leave her at a desk with an iPad. She takes a 6-year-old into a hazardous production facility. We are talking about an active industrial area with heavy machinery and welding equipment.
Where visitors require strict safety induction.
Exactly.
I mean, that is a catastrophic breach of workplace health and safety protocols. The liability for the employer in that moment is astronomical.
So management confronts her about it, obviously, but her reaction is not to apologize or recognize the danger. She completely loses it.
She just escalated the situation.
Big time. She slams her hand on a desk, starts yelling aggressively at her managers right in front of her child. It gets so heated that her own 6-year-old daughter is quoted in the case files as saying, "Mom, I'm scared."
That's heartbreaking.
It is. She then abruptly leaves the workplace. After that, the company tries to hold performance meetings, and she refuses to attend for over a month, claiming she needs legal advice. Finally, they fire her.
And she files a general protections claim.
Yeah. Here's where it gets really interesting. Claiming that her firing was due to her pregnancy after she brought a child into a welding zone and screamed at her boss. It's essentially like getting pulled over for reckless driving, going 100 miles an hour through a school zone, and then blaming the police officer for writing you a ticket because they don't like the make of your car.
That's a pretty accurate way to describe it.
It is an attempt to use a completely separate, protected trait to obscure your own dangerous actions.
And the reason her general protections claim completely failed in federal court comes down to one of the most vital mechanisms in workplace relations.
Yeah.
Prior documentation.
The paper trail.
Exactly. Remember that reverse burden of proof we discussed. The employer had to prove they didn't fire her for being pregnant. The court didn't just look at the safety incident in isolation. They looked at the timeline.
What did the timeline show?
Alight had meticulously documented Talagon's performance issues, her poor communication, and her lack of attendance all the way back in May 2022.
Which was months before she even announced she was pregnant in February 2023.
Right. The timeline is the ultimate defense for an employer. If you can prove you were managing a performance issue before the protected characteristic even existed, it completely dismantles the employee's claim that the performance management is a discriminatory pretext.
That makes total sense.
And the court explicitly noted that asking an employee how they intend to perform their work while caring for a child isn't discrimination. It's basic operational management.
She also tried to claim that the company breached the national employment standards by denying her carers leave on days she just didn't have a babysitter.
Yeah. This is a crucial legal distinction that many people misunderstand. And the mechanism of the law is very specific here.
How so?
Under the Fair Work Act 2009, Carer's leave is not a universal backup plan for a lack of general childcare. The statute defines carer's leave as a statutory safety net for emergencies.
So, like, if your kid is actually sick.
Exactly. If your child wakes up with a severe fever or breaks their arm, that is an unexpected illness or injury. That triggers the leave. But simply not having a babysitter because your regular daycare is closed, or because your partner's fly-in, fly-out rotation got extended.
It doesn't count.
The court ruled that is a logistical scheduling issue, not a medical emergency. You cannot legally force your employer to absorb your standard childcare logistics under the guise of statutory carer's leave.
So the verdict comes down and the employer completely wins. They proved the termination was for a valid reason: a major safety breach, aggressive conduct, and a repeated failure to engage in performance procedures. The worker's claim is entirely dismissed.
The contrast between Duarte and Talagon perfectly highlights how the Fair Work Commission and the federal courts weigh evidence.
It's night and day.
It really is. In Duarte, the employer had no valid reason for their actions, zero documentation to support a defense, and clear evidence of systematic cruelty. But in Talagon, the employer had a documented history of reasonable management, a clear and severe safety violation, and a robust procedural timeline that existed entirely independent of her pregnancy.
It really shifts your perspective on the broader landscape of workplace battles in Australia, because these two cases, as dramatic as they are just the tip of the iceberg when you look at the AWDR case files.
Oh, there was so much more in those files.
The sheer variety of workplace chaos out there is mind-boggling. Just looking at the headlines from the sources, I mean, you have a $37 million HR manager fraud that led to a massive dismissal case.
That one was a mess.
You have an employer who, instead of paying out a worker's legally required redundancy, decided to spend $2,500 on birthday cakes for the office.
A creative, if highly illegal, accounting strategy that did not hold up in tribunal.
I mean, birthday cakes. Really. But I need to talk about the satanic rubber duck prank.
Yes.
Because reading that in the case files completely broke my brain. A satanic rubber duck prank somehow escalated into a $15,000 unfair dismissal payout for the worker. I don't even know how you explain that one to your family at the dinner table.
It sounds absurd, I know, but it perfectly illustrates the ironclad nature of procedural fairness.
Walk me through that, because it sounds crazy.
Let's say an employee leaves a bizarre, demonic-looking rubber duck on a colleague's desk as a prank. The colleague is upset, the manager is furious, and they fire the prankster on the spot.
Right, they cause a disruption, I fired them, case closed. That's what a business owner would think.
And the law completely disagrees. Unless someone is committing gross misconduct, like physical violence or severe theft, you cannot skip the procedural steps. You have to formally investigate the rubber duck incident.
You have to investigate the duck.
You do. You have to give the employee a chance to explain themselves. Maybe they didn't know the colleague had a phobia, or maybe someone else put it there. If you skip the investigation and the formal warning process, the dismissal is procedurally unfair, regardless of how weird the prank was.
That is wild.
If we connect this to the bigger picture, whether you are talking about a diplomatic embassy, an industrial welding facility, or an office dealing with satanic rubber ducks, the underlying currency of all workplace rights is procedural fairness and documentation. The law does not care about your feelings. It cares about what you can prove.
So what does this all mean? For you listening, whether you're an employee navigating a nightmare boss or an employer trying to manage a difficult team, it synthesizes the absolute value of specialized representation.
It's crucial.
When an employee is in the middle of a crisis, dealing with the incredible stress of job loss, the financial panic, or the emotional toll of a toxic environment, they are not thinking clearly.
You're in survival mode.
Exactly, and that is when they make the critical mistake we talked about earlier, grabbing the sledgehammer instead of the scalpel and filing the wrong type of claim.
And mixing up a general protections claim with a standard unfair dismissal claim can be fatal to a case.
Because of the different rules.
Right. They have different burdens of proof, different compensation caps, and most importantly, incredibly strict filing deadlines.
Yeah.
Specialized support from workplace relations representatives ensures that the legal strategy matches the reality of the evidence before those 21-day deadlines expire.
Because when a job ends, your rights do not end with it. That is the core takeaway here. The legal system absolutely works, but only if you have the right strategy, the right evidence, and the right guide to help you navigate through it.
This raises an important question, though.
Oh, what's that?
Well, everything we've discussed today, the storeroom at the embassy, the hazardous production floor at the industrial supplier, The colleague's desk with the rubber ducken, these are all physical spaces. But the sources also touch on the rise of flexible working arrangements in 2025 and how they have fundamentally reshaped recruitment and retention.
Right, the post-COVID permanent shift to working from home.
Yeah. If the physical workplace was the main battleground for both Duarte and Talagon, how will the definition of workplace rights and misconduct fundamentally change as remote work fully detaches us from the office?
That's a really good point.
If your home is your office, how will courts judge a toxic work environment in the future? Where does the jurisdiction of an employer end and the sanctuary of a home begin when they are the exact same physical space?
Oh, wow. If a boss yells at you over a Zoom call while you're sitting in your own kitchen, is your kitchen now a toxic workplace? That completely rewrites the rules of engagement.
It's going to be a fascinating legal frontier.
Yeah. We will leave you to ponder that one because it is a fascinating puzzle and a whole new frontier for the mechanics of workplace law to figure out. Thank you so much for joining us on this deep dive. Stay curious, stay informed, and remember, if your workplace machine starts making strange noises, make sure you pick up the right tool before you try to fix it. We'll catch you on the next one.